it depends. So let me start first off with determinations of non-dischargeability. So if a creditor wants to challenge the discharge of a debt under one or some combination of the three theories I mentioned earlier, fraud, breach of fiduciary duty, or willful and malicious harm, it has a very short statute of limitations. In order to understand this statute, let's consider what happens in a bankruptcy case. So the debtor prepares and files a petition. Then something on the order of a month later, plus or minus a few days, it depends on how busy the court is, the debtor will attend a hearing. It's called the Meeting of Creditors under Section 341A of the Bankruptcy Code. When the debtor walks out of that hearing, although nowadays the hearings are being conducted via Zoom or over the telephone, so there isn't a physical walking out, a 60-day clock starts to tick. If we get to day 61, with the understanding that if that's a weekend or a holiday, it does spill over to the next business day, if no one has filed a complaint to initiate an adversary proceeding under one or some combination of those three theories, and no one has filed an adversary proceeding under a different theory to challenge the entire discharge, they forever lose the right. So that's a very short statute of limitations. There may be a problem with the underlying action. Let's say you're saying, well, this debt was incurred through fraud. But let's say the statute of limitations for fraud is long since passed. Then filing the adversary isn't going to take you very far because the underlying debt is not subject to a court action. So, for example, in California, if you have a debt that's, let's say, a credit card debt that was incurred more than 4 years ago, then the statute of limitations is what's called an affirmative defense. So filing the adversary proceeding isn't going to take the creditor very far, because if the debtor can establish that the statute of limitations defense is valid, then the debt is going to be discharged even if there was fraud involved. So in that situation, it does depend on the term, the underlying debt. Now, if we have an adversary proceeding to avoid, let's say, a preference, then it depends on the type of creditor that received that preferential payment. If the creditor is an ordinary creditor, then measured from the day the debtor files the petition, the trustee can go back 90 days from the date the check clears and avoid all preferences in that window. If the creditor is an insider creditor, there's a bit of a technical definition of an insider creditor. Just think family members, close business associates. Then the trustee can go back a year measured from the petition date. So that depends on the nature of the creditor as to what the statute of limitations is there. And then for fraudulent transfers, things become much more complicated. So the Bankruptcy Code in Section 548 has a statute of limitations for fraudulent transfers measured from the petition date, and that is 2 years. However, the Bankruptcy Code does permit a trustee to piggyback on non-bankruptcy fraudulent transfer statutes. In California, the non-bankruptcy fraudulent transfer statute has a look-back period of 4 years with additional time up to 7 years. Now, there's a wrinkle to that one, too. Normally, everybody latches onto 4 years from the date of the transfer. But the statute also says, or, so there can be an alternate theory here, or when the debt to the creditor was established or confirmed, as it were. And so that means you could conceivably have a transfer that took place quite a while ago. Then the creditor gets a judgment subsequent to that. And now we've got 4 years measured from that with additional time up to 7 years if the transfer couldn't have been readily discovered. So you could have a lot more time. And then if the debtor, when the debtor files that bankruptcy petition, has a debt to the IRS, the trustee can piggyback on the IRS's statute of limitations, which is 10 years. Now, I will say the California statute and the IRS statute are not measured from the petition date. That is the date that the debtor files the bankruptcy petition. Instead, they're measured from the date the trustee files the complaint. So it does get to be a little bit complicated. And if you've been watching this video and you didn't quite follow all that, and you live in the Central District of California, give me a call and we'll talk about this. Sometimes I get calls from people in New York or Pennsylvania or Michigan. I am not licensed to practice in those states, so I really can't help you. In fact, it's against the law for me to give you legal advice, because if I do that in a state where I'm not licensed to practice law, then I am practicing law without license. But if you are in the Central District of California, which includes Los Angeles County, Orange County, Riverside County, San Bernardino County, and Santa Barbara County, although I don't really take Santa Barbara cases, then you can give me a call and I'll chat with you for a bit. In any event, statute of limitations in adversary proceedings is a complicated concept, and there are all sorts of twists and turns that can trap the unwary and the ingenue. So it's best to contact an attorney that knows what's going on to determine whether or not, if you are the one who wants to file the adversary complaint, you've already lost because of the statute of limitations being expired, or if you're a debtor, whether or not you could conceivably use the statute of limitations as a defense.